doctrine of transformative constitutionalism. Now, this doctrine is very much in the news, and particularly in the last 3-4 years, Supreme Court has been invoking this doctrine quite frequently. And lately, in LGBT case, where the constitutional bench is discussing the matter, this doctrine has come forward. So, the first thing is that what exactly is doctrine? Doctrine is something that helps the constitutional court to interpret the constitution in certain frameworked manner. In case of judicial review as well, they take those doctrine into account. All right. So that is what doctrine is. And secondly, that what exactly this transformative constitutionalism entails. Is it an Indian innovation? So the answer to this question is no, not at all. Is it a new thing? Again, not at all. So the origin, the genesis of this doctrine, transformative constitutionalism, goes back to 1998, particularly in South African jurisprudence, sorry. So Professor Karl Klare wrote extensively about this doctrine, and that has laid the foundation for discussion related to this doctrine in other countries as well. So it's old doctrine, you can say. Recently in India, it is being used. Now, let's understand what exactly this particular doctrine means. See, transformative simply means transforming means from one position to another position, to bring certain change. And when we say constitutionalism, so there could be many definitions of constitutionalism, but for the purpose of understanding, constitutionalism simply means to prevent the autocratic tendency of the government. That the government should behave not in an arbitrary manner, rather they should behave in a rational manner, they should behave in a very responsible manner. So this is the genesis, this is the basis, the bedrock of constitutionalism. So if there is any student of political science or law, they would be knowing about Grenville Austin. Grenville Austin emphasized a very important point. The point is that he said that the Indian Constitution is first and foremost social document. Now the question is, why did he connoted Indian Constitution as a social document? So here, the purpose he is trying to emphasize, that the purpose of the Constitution is not just to give power, authority or rights to the people or the government. Okay? Purpose is to bring desirable social change. It will become a bedrock for the social devolution that is there. So India is on the path of social transformation and through the method of constitution. All right. So constitution, so in the eyes of Grenville Austin, as he said, first and foremost social document, it indeed is first and foremost document. So the purpose is to bring desirable social change, social engineering, all these things is needed. All right. So one thing I would like to say, how this social change moves actually. So let's imagine a situation of Indian society in 1947. The society was very conservative from today's point of view, you can say. There was many social ills like child marriage, dowry system, this untouchability, so many social ills were there. But somehow we graduated ourselves and we have somehow weeded out those social ills, and we have reached to a juncture where one could say that India is by and large a modern society. So society is a dynamic idea, is a dynamic concept. So when the social idea, which is traditional in nature, doesn't befit the contemporary requirement of the time, if it is not befitting, if it is not in consonance, if it is not in harmony with the present requirement, then those sort of social construct must be struck down. So rightly so that in many cases Supreme Court invoked this transformative constitutionalism doctrine, and Chief Justice Chandrachud also highlighted while defining what exactly he meant to say when he says transformative constitutionalism, he explicitly said that it is based on the bedrock of equality, liberty, fraternity, and dignity. These are the 4 words that he said, and rightly so. So, if you take the example, some of the cases, for example, Sabrimala temple, where this transformative constitutionalism was invoked, so is constitutional morality. So, in Sabrimala case, women were not allowed to visit the sanctum sanctorum of the temple. Now, this was discriminatory. This was discriminatory, particularly Article 14 was violated. All right? Equality is not there, people said. So, when there is no equality, definitely there is violation of fundamental rights. So, they tried to strike it down, strike a balance between these new emerging trends. The Supreme Court in that matter said that no, it is against the equality. All right. Similarly, in the present matter that is going on, that related to LGBTQ, gay, lesbian, those sort of marriages. In those matters, Supreme Court again invoked this doctrine and said that yes, the needs, the requirements has to change, has changed. So is the law. The law has to change according to the requirements. So in other judgments as well, they said they move from this binary idea of gender to 3-gender system, particularly where transgender was also accorded a legal status at par with your male and female. So society changes, requirements changes, new ethos is emerging, new values are emerging. If such values are not protected within the confines of the Constitution, then the meaning of the Constitution as the first and foremost social document will lose its significance. Therefore, it is important that Constitution should be interpreted in the light of new and emerging trends. So basically, transformative constitutionalism is all about this. I hope this video made you understand what exactly is transformative constitutionalism. I will be bringing similar other videos. Next video will be on constitutional morality. Thank you.